Hello, my name is Thorne Barasa, the president of the ICJ in GLUNS, and today's class shall be oral arguments. Well, we've been told many times lawyers like to argue and lawyers like to do this and lawyers like to do that. But an argument in this case isn't, just two people shouting. An argument is you presenting your case before the court. For you to present your case before the court, you need to make a legal argument. And so we've already looked into how a case is brought. An application has been filed, a memorial has been written. Now you will appear before the court. And when you appear before the court, you appear as an agent of the state. So oral arguments in this instance, we look into the structure of oral arguments. We look into judicial questions, because within the moot court setting, you will get questions from the bench. We look into etiquette, we look into strategies and other common mistakes. So what are oral arguments? Oral arguments are the live presentation of your case. You have written it on paper, you have done applications, you have done written submissions. You will then move along into doing oral arguments. Why is this important? Persuasion, clarity, and responsiveness to judicial questions is very important. Persuasion, this is how you persuade someone, how you make the judge, the bench buy into your idea. And you can only do that if you do that in a logical and clear way. And as I've said, these oral arguments are fashioned within the style of a moot court. A moot court is a simulation of international legal trials where counsels bring forth their cases, and as they are speaking, they get questions from the judges. So the oral argument builds up to your memorial. It does not need to be a carbon copy, and we strongly advise that your oral argument is not a carbon copy of your memorial. You can always improve your memorial. You can always change your arguments. Unless specifically stated otherwise, you are not bound by your memorial. You don't have to say everything in your memorial. So it's an opportunity to reinforce key legal issues, to respond to judicial question, challenge opposing counsel's reasoning, and demonstrate mastery of law in a dynamic setting, where now you appear before a judge dressed in a suit like mine, and you stand as an agent of the court. And for you to be able to do that, you do that in an oral argument. That's what it is. But what is it not? As I've said, it is not a repetition of your memorial. Delegates should not read verbatim from their written submissions. Meaning, you're not going to stand before the court and give us a presentation of your memorial, no? You're going to stand before the court and you're going to argue your case out. If anything, delegates who carry their memorials to read out or carry a script lose marks, because that does not engage the court. You have prepared a written submission to be read at a different point. This is an oral argument. And in the MUN context, as I've said, you act as the legal counsel for your assigned state before a panel of judges. And the moot court format is mirrored in the ICJ, because it is you appearing before a court, as I've said before, as the agent of your state. Now, structure of oral submissions. You can present your argument in a number of 3 ways, but these 3 must always be there. First, opening statements. Now, for those of us who watched your legal dramas, Lincoln Lawyer, Suits, you see that point where now the counsels open the floor and they talk about a summary of their case. In a moot court setting, you might not be able to do that fully because you'll have limited time, say 20 minutes or 25 minutes to make your case. But an opening statement is very important, and this is how you present yourself to the court. And to everyone watching this, there is a structure to making an opening statement. You need to come and introduce yourself, say what side you're speaking, what side you're representing, how much time you will take, and give an outline of your argument. For example, something of this sort. Judge President, Your Honors, may it please the Honorable Court. My name is Thorne Barasa, and I appear as counsel for the United States as the applicant state in this matter. In the next 15 minutes, I shall canvass the issue on jurisdiction and whether there has been a violation of the UN Charter as alleged by the respondent. After which I shall then pass the remaining time to my co-counsel to handle the next two issues. With the leave of the court, I will begin. That is the salutation. Then the opening statement shall be a brief summary of your argument and how you intend to do that. So for example, with regards to the issue on jurisdiction, I shall take the court through the fact that the applicant state has temporal jurisdiction, personal jurisdiction, and subject matter jurisdiction for this case to be heard. For the second part, I shall outline how certain articles of the Charter have been violated by the states by showing that this extent amounted to this and this other act amounted to the other thing. And with that, I will then make my argument. So the opening statement serves as a salutation, an introduction to your case, and what you're going to do. This outlines the structure of your argument and it makes sure that we can follow through what you're saying. And the second thing is now the actual presentation of your argument. So the same way you did your memorial and you did the analysis of a legal issue using the IRAC formula, the IRAC formula being issue, rule, analysis, conclusion. That is exactly the same way you will present your legal argument. And you focus on your strongest arguments because your memorials has you looking into many things, but you need to focus on your strongest arguments and you need to say them as early as possible so that you lead with that. And not only that, but also connect the facts and the law precisely within your legal issues. Meaning, as you present your legal issue, I should hear, this is the issue, this is the rule, this is how it applies to the present case, and this is what I am asking for as a result. And of course, the conclusion or the prayers that are done in the end, which is a brief summary of the arguments made and what you want the court to then rule on. So that is the structure of your oral submissions. And as we said, within the moot court setting, you will have judicial intervention or questions from the bench. So judges will interrupt you as a delegate. And I know that sounds scary, but just before I go on, I'd like to tell you that judicial intervention or questions from the bench are not the judges trying to attack you. They are the judges trying to get you to score more marks. Why? Because judges will stop you to ask questions, to seek clarifications, and to challenge your arguments, which is central to the moot experience, to test how good you are as an agent. So how do you handle these questions? You do 5 things. First, and the most important part, is you listen. Listen to the question. How do you listen to the question? When the judge starts speaking, you stay quiet and you do not interrupt the judge until they're done asking their question. Most counsels end up answering the wrong question because they heard what they thought the judge was asking. So you listen. And where you are not sure, you can seek a clarification and you say, Your Excellency or Your Honor, is your question that this and this is that's how you do it. So you listen to the judge. Never interrupt the judge while they're speaking. The judge can interrupt you as an agent, but you can never interrupt the judge. 2, acknowledge receipt of that question. This might not be entirely important because it gets redundant as you do it every time. But I'd advise that you use the acknowledgement tactic, especially when you get more than one question from the judges. So one judge asks you one question and then the other judge asks you another question and then another judge asks you one question. So you have 3 questions. How do you acknowledge? You say, I notice the concern from the bench and with the permission of the judge president, I would like to I'd like to address this judge's question first before this one and before the other one. You've acknowledged their questions and you've even asked for permission to handle this question first because it ties to your next point, which will handle this other judge's question. It does not mean you always say, thank you for your question, thank you for your question. I mean, many coaches will train you like that, but in my experience, I found it becomes a bit redundant, especially as a judge. When you thank me for my question every other time, just answer my question. 3, answer directly. Answer what the judge has asked you. Answer it succinctly, answer it clearly and directly, and move on. The problem most agents have is you get a question and you want to say everything you know about that specific issue, and that then leads to you even digressing. If the judge has asked you something, what you should pick out in your head are the operative parts of the question, which are the WH questions. Is it who? Is it what? Is it why? Is it where? Is it when? Is it how? Once you've picked out the operative part of that question, the response should only answer that part, and then you move on, because you risk answering too much and opening yourself up to more questions. 4, which is also equally important as step number 1, stay composed. People have very good presentations. You'd have an agent has had a stellar presentation until they get asked a question and they freeze. As I've said, it sounds very hectic. Some agents' bodies don't know the difference between being held at gunpoint and receiving a question from a judge. But there's nothing to worry about. As I've said, it's not the judge trying to attack you, it's actually the judge trying to challenge you. And if you win the judge's challenge, you've won marks. And 5th, bridge back, turn back to your argument. Once you've answered the question, don't linger and wait for more. Go back to your argument, because remember, you need to ensure that you're within time. Therefore, the judge has asked a question, you've answered it, pivot back to your argument immediately. How do you do that? You've been asked a question, and where is this source found? According to Article 38 of the ICJ statutes, we can apply ICJ cases which are a persuasive source before the court, and as such, we submit that we can use this case as an authority. Going back to my argument, Your Excellencies, we submit that this and this, that is exactly how an oral argument is done, and that is exactly how you pivot back to your argument. And of course, to do all this, it helps to know what type of questions they are. And there are 4 types of questions. We have clarification questions. These are when judges want to understand your argument better, or want to understand the point you're trying to get at better. So you need to explain more clearly. For a clarification question, all you need to do is just explain what you're saying more clearly. Second, there are hypothetical questions. A judge will pose a hypothetical to test your legal reasoning. For this one, you just engage the hypothetical. Assume that is the case you're then handling and apply your reasoning there. Meaning you need to be very well versed with the law, you need to understand your case well, and you need to know how to think on your feet. And then there are challenge questions where the judge pushes back on your argument, either by saying what the other side will say, or just by asking, okay, but why should we adopt that? Why should we do that? So you've said something and the judge pushes back. Defend your position respectfully and with authority. That's the only way to get out of that question, because the judge is not trying to push back to say that is not true. The judge also tries to push back to see if you will adopt your position, if you believe in your position, and if you do so, no one can convince you out of it. So for a challenge question, all you need to do is to defend your position, but do that respectfully. People get challenge questions and now they start getting annoyed because they feel like the judge is disturbing them. The judge wants you to feel that way to see if you will crack under pressure. But as we've said, step 4 of handling questions is to stay calm and to stay composed. And that helps you challenge questions. And the last one is friendly questions. The judge genuinely wants to hear more about what you're saying. And the judge wants you to expound on a point, and take that opportunity and strengthen your case. Like the judge asks you, are there any other claims? Are there any other sources? Is there anything more to this matter that the court should be aware of? The judge is extending an olive branch to you to ensure that you do really well. So for friendly questions, take them and run with them. Take that opportunity to strengthen your case. And so there are things you need to know: etiquette, strategy, and the mistakes to avoid. So for etiquette, as you've said, you're a counsel, you're an agent for your state. Therefore, you need to address the court with respect. At no point will you call the judges by their names. At no point will you call him he or she or that man. It will be Your Excellencies, Madam President. Madam President would be then if there is a judge president, because there's the presiding judge who is also called judge president, and then there's the members of the bench. So you'll call them Your Excellencies, Your Excellency, Madam President, Mr. President, members of the court, members of the bench. You need to be very respectful. And as you said in the beginning, you start by saying, may it please the court. Madam President, members of the bench, may it please the court. When you finish, you also say that, may it please the court. You can refer to your opposing counsel as counsel for the respondent state, or opposing counsel, or learned counsel. You don't need to start calling them by their name or that guy from that side. No, you need to be very respectful. 3, speak clearly and at a measured pace. You need to speak clearly to ensure that you can be heard. Don't rush over your points. That normally shows that either you are not clear in what you're saying or you have not mastered your content. So speak clearly, speak at a measured pace. Stand when addressing the court. You will never address the court while seated. You will stand while addressing the court. You cannot interrupt other counsels when they are speaking, and interruptions include but not limited to making faces or making reactions when the other side is speaking. Of course, the other side is not coming to agree with you, so they're going to say something that contradicts your case. But you can't now start shaking your head very violently or start throwing hands or start making faces. That is disrespectful. Of course, professional dress and demeanor. As an agent of the court, you will need to appear before the court in a suit, like mine. But more specifically so, you will appear before the court in a suit. And of course, you need to begin and end formally, as you said, may it please the Honorable Court. Strategy. For strategy, it is important that you prioritize your strongest arguments, especially when you see that time is running out. Go to the point where it wins you that argument or it wins you that issue. Most people speak about preliminaries so much that they forget that that's not important. The importance is, what does the court need to answer today? And once you answer that question clearly, it helps you. That is your strongest argument. You can anticipate judges' questions in advance. So as you prepare, as you are doing your research, you can see that, okay, this is a bit unclear. The judge might ask me this question, and so you start preparing a response. That is exactly where confidence comes in. Kobe Bryant said the reason why he's confident is because he's done everything he can to prepare before a game. So there's no reason why he shouldn't be confident. And so for you as a delegate, once you've anticipated a question and you've done your research and you've prepared for it, once that question comes, it's your chance to shine. It's not a chance to crumble, And prepare rebuttals to the other side's points, because you will present your case and then you will present rebuttals. So also know how to challenge the other side's points when given the chance to respond to them. Of course, adapt to the bench reactions in real time. If you see you've said something and a judge frowns or a judge raises one eyebrow, it means they haven't understood it. So you can take your chance to explain that point better and then move along with the bench. If you see the bench is satisfied, they're nodding after you said something, clear up that point and move on to the next one. Very important, time yourself so that you understand how long your arguments take. You understand how to phrase what is important to come first, and so that you also stay within time, because if you go over time, then you lose marks as well. Always reserve time for judicial questions. So for example, in my introduction, I said I'm taking 15 minutes. But in real sense, I'm timing myself to take 12 minutes because I'm assuming within 3 minutes, I will get questions from the bench. I will need to clarify things. I will need to explain something. And that is how a smart counsel plans their time. And of course, know your argument inside and out. Not just your memorial, but know your argument inside and out. You need to know what you're saying. Which brings me to my first mistake, which is reading your script word for word. In fact, I will go as far as saying never carry a script to the court. Never carry a script. You can carry pointers, you can write pointers, summary of your arguments in small points, what you need to say, your authorities. But never carry a script before a court, because a script becomes a clutch, and without a clutch, you can't walk well. So never carry a script. 2, always answer a judge's question. This happens mostly when you get more than one question, and so you become very scared. You only answer the question that you can, and you don't answer another judge's question. That is also bad. You lose marks for that. So always make sure you acknowledge and answer all the judge's questions. If you have too many arguments, it means we can't even focus on one. So focus on your main argument, your primary argument. The other arguments can be elements or metrics or parameters building up to your main argument. But always focus on your main argument. Another mistake is speaking too fast or too quietly. And too loudly as well, because there are people who think the loudest counsel is the one who wins. People who think the loudest lawyers are the best lawyers. Yeah, I have news for you guys. The loudest lawyers are not always the best lawyers. If anything, they are compensating for something that they don't have. In this case, I won't speak to that, but that's not the point. And so, as I'm trying to say, in any situation where you are confronted by the judges or confronted by the bench, you're supposed to speak in a measured pace, not too slowly. Don't drag your words to try and now ensure we can hear you. I can guarantee you we can hear you even if you speak this way. And also make sure that you speak, you're audible enough. Everyone can hear you. You're not too quiet. The judge doesn't have to lean forward to hear what you're saying. Neither do I have to, think that I should wear my pods because you're speaking too loudly. Losing composure under pressure. I know this is something you cannot have control over to an extent, but composure also comes by you having done and having rehearsed your arguments over and over again. And one of the reasons as to why someone can lose composure under pressure is because you're getting very many questions from the judges and you are running out of time and you are looking at your points and you can't even see your next argument, so you start losing composure. And that's why we said clarity matters, structure matters. And if you've mastered your argument in and out, you can go as far as not even needing anything so that you understand how your argument flows. You need to understand how your argument flows in your head. And so the pointers just help you get there. The pointers are, this is your key argument, these are the authorities you're using, and that is all you need. A flashcard or two at most. One, to write questions in the event that you get questions from the judges, which is a good tactic to ensure that you remain composed. A question can be very hard, but you just, pick a flashcard. You write the operative part of the question quickly so that you can also answer the right thing. But as well, master your argument, ensure you understand what you're saying, and you cannot lose your composure then. Also, positive self-talk before the moot itself or before the round itself. Talk to yourself, talk to your teammates. If you have a teammate that feels a bit overwhelmed, a bit scared, I recommend talking to each other, explaining exactly how you're feeling, being honest about how you're feeling, having a small routine you can do for yourself and as a team to ensure you calm yourself down. It's a very high pressure situation, but diamonds are made under pressure, so it's only fair that we subject you to the same. We promise we'll be nice. And of course, ignoring time signals from the bench. There are people who they presume the time is theirs, and so you cannot tell them that they're not done, and they run out of time, and so they just continue speaking. That is honestly just disrespect. So when time is done, you can notify the bench that I recognize that my time has elapsed. I'd like to request an additional 1 minute to wrap up my argument. And if the bench is kind enough, they can grant you the minute. But do that before your time runs out, because once time runs out, you will not be allowed more time. So if you're going to ask for more time, you can only do that once your time is still running. And with that, ladies and gentlemen, that has been our class on oral arguments. We shall do this more practically and more, moot, you only get better at moot court by doing. So we shall do this more practically, and I will see you on the next one.